and Boston of the Boston Law Group, LLC. We're a premier husband and wife legal team in the state of Maryland. Thank you for joining us today for another episode of BTV, where Boston Law Group, us, provides you with answers to legal questions that you may have throughout the state of Maryland. Now, I'm joined today by my husband, Marcus Boston.
Hello.
And we want to talk to you briefly about driving under the influence cases. And Marcus, if you could start and kind of give us a brief scenario on any preliminary issues as far as what happens when someone is arrested and charged with driving under the influence or alcohol-related driving offense.
Okay, well, actually, the question that we had that actually is the reason why we're actually shooting this particular video is it actually deals with a person had a question regarding the 10-day administrative hearing which you must respond to or you must request if you have been driving under the influence or if you've been charged with driving under the influence or driving while impaired. And the reason why this is important is because a lot of people, they blow past this 10-day requirement and they're really not really sure one way or the other as to whether they actually need to request the hearing. What does the hearing do if they have to go to the hearing? So there's a lot of confusion as to that 10-day hearing. And what I'm going to try to do is quickly give you like an overview of why that is important and why you should request that 10-day hearing, especially if this is your first time being charged with DUI or DWI. The main reason that you want to request a hearing is because on day 46, your temporary license is going to be suspended. Now, the reason why that is important is because at the time of your arrest or your citation, the officer gave you or should have given you what we call the DR-15 form, and included in that is the officer's certification and the order of suspension. All of that stuff goes together. But the important part of that, and what the officer should have told you or what you should have read in your advice of rights form, is that when the officer confiscates your license or at the time of the arrest or the citation, you can only drive temporarily in most instances for 45 days. And after day 45, your license are suspended. Now, from the time of arrest and citation, you have a 10-day window in which you have to request your Office of Administrative Hearing. And the reason why this is important is because during that 10-day time frame, if you request your hearing during that time frame, then your license will be good, your temporary license will be good until your suspension hearing. So if your suspension hearing goes out past your 45 days, your license will not be suspended.
Now, let me ask you this, and we can kind of break it down so that way the viewer can have a better understanding using just made-up dates. Like, say, for instance, I get stopped, I get pulled over on January 1st. And so are you saying that by January 10th, that's my 10-day window?
That's your 10-day window. You have to request your hearing within that time frame because what's going to happen is 45 days from January 1st. That's how long you have that you can drive on your temporary license.
So back to my example scenario. If I get pulled over on January 1st, the officer's going to give me a temporary license where I can drive for 45 days, which will probably take me to around February 15th.
Right.
So that's, if we're just saying, 30, 45 days or whatever. So I get stopped on January 1st, February 15th, I can continue to drive. So are you telling me on February 16th, if I don't do anything, I can't drive after February 16th?
Right, and that's what a lot of people don't understand. On February the 16th, if you have not requested that 10-day hearing, then your license are going to be suspended. Now, the law does allow you up to 30 days to request an administrative hearing. But the thing is your suspension will take place on the 46th day, regardless of if you have requested your hearing within that 30-day time frame. If you have requested the hearing outside of those first 10 days, so let's say you request your hearing on day 15, well, if you have your hearing beyond day 45, then your license they're going to be suspended on that.
Okay, I got you now. So it seems like the 10 days are pretty much they give you the it's like a 10-day incentive to get it done early, so
Right.
that way you either won't have your license suspended as soon, or you'll have an opportunity to
Challenge it.
challenge it.
Right.
Okay.
Challenge suspension. Right. And that's really very important. And a lot of times this information is on your DR-15, on your advice of rights form. It's actually there, but
I
a lot of
actually
times.
have a copy of one
Okay.
here. If you want.
Yes, okay, and this is it. It is the advice of rights, DR-15, and it's specifically. I don't know if we can, if specifically, but this is kind of what the form will look like. And this form is what the officer has to read to you. You have to look it over, and based on this form, at the bottom of the form, the officer will check whether you actually agreed to take the breathalyzer test, or whether you refuse to take the test. Now, and I know this is kind of outside of the question that we were asked, because the question specifically dealt with the 10-day rule.
Right.
But what a lot of people don't realize is that if you refuse to blow on your first time offense, your license are automatically going to be suspended for 120 days. So right off the bat, you're gonna, because if you refuse to blow, they're gonna suspend your license for 120 days. And if this is your second time with it, then you've got up to a year is what the suspension is going to be. So again, now there are some ways that you might, and I say might, be able to get around that suspension with the interlock device and some
Right.
things like that. But that's for a separate video. So specifically, they would have to be looking at 120 days if you refuse to blow.
Okay, now let's go beyond. So we've helped them out with that 10-day rule question, but let's go on a little bit further into the administrative process. We got time to do that?
Yeah, I think.
Okay. A brief question is, well, if this is my first offense, what chances are, what am I looking at as far as suspension?
Okay, well, on your first time offense, if the administrative law judge finds, if the judge does find against you, then you're looking at about a 45-day suspension on your first time offense. If it's your second time, then you're looking at 90 days. If it's 2 or more, you're looking at about 90 days. Now, again, this assumes that you blew a .08 also.
Okay.
So if you blew a .08, then that's what you would be looking at. If you blew between a .08 and .15, you're looking at a 45-day suspension for your first offense, 90 days for your second offense. Now, if you blew more than if you blew a .15 or more on your first offense, now you're looking at a 90-day suspension. And if this is your second or more time blowing .15 or higher, now your time is going to go specifically. It's going to go up. You're looking at, I believe, 180 days is what you're looking at, suspension wise.
So the bottom line is that 10-day time frame from the time the officer gives you the advice of rights and the certification of the DR-15 form to 10 days after that, that is the most crucial time period that you have if you've been charged of an alcohol-related driving offense.
Yes, it's very crucial, and a lot of times, because we do have clients who tell us they come to see us after they have retained the office of the public defender on their criminal case, and what they'll do is they'll say, well, Mr. Boston, my public defender took care of this for me. My public defender, I thought that they took care of this. And what happens is, what a lot of people don't understand is, the administrative hearing is a separate hearing from the criminal hearing. The Maryland law views these administrative hearings as a separate entity in and of themselves. So what happens on the criminal side, really the administrative law judge does not have to take any of that into consideration, because this hearing is a separate hearing. So while your public defender or your attorney on that other side may have helped you out on that with the criminal aspect of it, if they did not come over and help you on the administrative side, you could still be looking at that 45-day suspension, even though you could have possibly gotten a PBJ, probation before judgment, on the criminal side. So that's why it is very, very important that you talk with an attorney and get as much information about this process, not only on the criminal side, but the administrative side. And that's the part where a lot of people, they miss the boat because they think that, like I said, I went and got a public defender, or my attorney didn't tell me that I had to worry about this administrative stuff too.
All right. And that's kind of where we come in. We actually have a book that we just wrote. You remember the?
Yes,
you want to tell us about
yes,
the book?
we do. We actually have a new book that we've just written that will help you if you have been charged with a DUI, DWI, or other serious driving offense, suspended license, reckless driving, some of these things that carry a lot of points, 12 points, 8 points, 5 points, because what happens, and the need that we felt to write this book is because a lot of times people don't understand that if in a 2-year time period, once you start accumulating more than around 8 to 11 points, you're going to get a notice from the MVA. Again, it's administrative stuff. You're going to get a notice saying that, okay, Mr. Driver, look, we're looking to suspend your license because you're getting too many points in a 2-year time frame. And then if you get 12 or more, they're looking to revoke your license. So that's why you really, really have to be careful. And a lot of times people just don't understand that tickets can really affect your life. Not only on the fine and the criminal side, but it's the points. A DUI in Maryland is going to run you immediately 12 points. A DWI, 12 points, 8 to 12 points in certain instances. So these things can off the bat, they can start you already on the road to suspension or revocation on the MVA side. So I say all that to say, if you are in this situation, request our book. You can send us an email at info@bostonlawllc.com. Again, that's info@bostonlawllc.com.
Or you can give us a phone call at 301-850-4832. Again, that's 301-850-4832. And you can just leave a message on the voicemail for requesting the book and your address and that kind of information. And we can have a copy of the book sent to you as well.
Right. And on the email side, as soon as we process that email, now you got to think, if you send it to us on a Friday night or a Saturday night, you got to give us time to process it. But normally, if it's within the week, we can get a PDF copy of that book right out to you, and then we can ask you some more information about your mailing address, and we can get a hard copy out to you in a couple of days. But it's very imperative that you get that immediate PDF of the book. That way you can go ahead and start reading it and start trying to find out specifically what you need to go forward in your case.
And you won't jeopardize that 10-day window.
That's right.
So the book is called Slow Down and Read, Things You Must Know If You're Charged with Driving Under the Influence or Other Alcohol-Related Offenses or any serious traffic offenses in the state of Maryland. So request the book, continue to check out this blog, check out our other videos, check out our other articles, and if you have any questions, you can also feel free, just like the last person did who submitted the question regarding this video, the 10-day rule question, you too can submit your own question at info@bostonlawllc.com. That's info@bostonlawllc.com. And again, thanks for watching. My name is Renee Boston.
And I'm Marcus Boston.
And we'll see you next time.
Bye-bye.